Now back to the show. This is The Law Show on CL 650.
Say goodbye to Hollywood. Say goodbye, my baby.
And welcome back to the Law Show here on CL 650. We're talking about executors, trustees with John Lakes and John White from Lakes White LLP in North Vancouver. It's the Law Show on CL 650. Now, John, before the break, we're talking about somebody that doesn't do enough as the executor of the estate. What is the flip side of that? Somebody that goes overboard.
Well, there are plenty of examples of that, and it's important to realize that when you're being a reasonably prudent executor, that doesn't mean you have to act like Donald Trump and try and turn $1 million estate into $1 billion estate. That's not your function as executor. The functions of the executor are what John Lakes set out, and a great example of an executor that went way overboard outside of his ability level and outside of anything that the will could possibly have asked of him. It was a recent case, came down last year, of a guy who basically was the executor of an estate that had a 10-acre property where the family had talked about subdividing the property even before the will maker died, but they'd never got around to doing it. And at one point, everybody seemed to be on board with the concept, but the executor, despite the fact that he had no experience in property development, decided that he was the guy who was going to subdivide this property and make a ton of money, likely with the best of intentions for the beneficiaries. But he made two serious errors. Number one is just going ahead with the project in the first place. He didn't seek advice where he should have sought advice. On one occasion, he did seek advice as to what a proper budget would be. And he was told some astronomical number, and he ignored it and went ahead anyway. But the court found that a reasonably prudent executor would not have proceeded that way. The other thing that he did that he shouldn't have done was he put himself in a position of conflict because he did a lot of the work. His family members did some of it. His companies did some of it, and they all got paid for this work out of the estate funds. That's a big no-no because that put him in a direct conflict of interest with administering the trust property. And the court came down pretty hard on this guy. He was found to have increased the value of the estate by a little bit. The court found he did some work, and some of it was good work. And he got credited for that, but he got paid something like 4 times the value of the benefit that he gave to the estate, and he had to pay that back, or he had to pay half of that back anyway.
So how much can an executor charge against the estate for sort of common sense sort of things, like accounting, going to see people like yourselves for advice?
And they can charge up to 5% of the value of the estate, which is taxable income, actually. If you get executive fees, you have to pay taxes on it. But there's a sliding scale. So to get 5%, you usually have to be involved in litigation. Probably around 2 to 3% is the norm. But quite often what will happen is people put a provision in their will to determine what the executor is to receive, or maybe give the executor a gift so they don't have to pay taxes on it as well. But they're entitled to their services. So.
And just to be clear, that's net of expenses. I mean, you are, as an executor, entitled, and indeed you should, retain counsel or other professional advisors to assist you with the job of being executor of the estate. And assuming that you do your job properly and they do their job properly, you should be able to recover those sorts of expenditures dollar for dollar out of the body of the estate.
Well, that's what you mentioned. You do an accounting of
yes.
This is how much the value of the estate. These are the expenses, and that's part of it, right?
Yeah.
Right.
And so you must handle a lot of this on the other side. When someone's passed away, you said it takes 2 years on average. So you're helping the executors stick handle this stuff?
Yeah, I mean, it depends on the nature of the assets and the nature of the family. So, for example, you may have 2 brothers who are the sole beneficiaries of the mother's estate, and they get along quite well together, and I might help them do probate, and I might help them sell the house and everything, but a lot of it they need an accountant to help them. They can do it themselves. However, under circumstances where beneficiaries are under the age of 19, or there's other, there can be litigation based on companies, and I mean, sometimes I act a lot longer than other circumstances, but every family is unique too.
Now, we talk about executors, but there's also trustee. Now, what is the difference?
Well, every will has to have an executor. Not every will needs to have a trustee, and there's a bit of an overlap. So a trustee is somebody who maybe there'll be money tied up in the will for a certain period of time. So the most common is for children under a certain age. So typically money will be kept aside till they're 25, with monies for education and health and welfare, and sometimes there's special clauses in there, such as if they're a high-level hockey player, or they're going to special school because they've Asperger's or whatever. So the person would be administering those funds, and they would decide how the funds would be paid, and they would pay monies to the guardians and so forth. The second one is there could be a trust for somebody's lifetime. So you have a child with a disability, and therefore they would
just to interrupt. So does the trustee need to go to the executor? Say you have a child that needs to go to a special school, as you mentioned. Does that trustee go to the executor and say, "Hey, we need to pay for this school"?
Well, hopefully it's the same person.
So they can't be the same
Yeah,
person.
it usually is the same person.
Okay.
It's usually the same person, and they would still have to account. First of all, they'd have to account to the children under 19 to their parents, who are the guardians. But second of all, they would have to account to the public guardian trustee as well. So they can't.
So is it your advice to have the same person?
Yes, it is.
Okay.
And a backup as well, in case somebody can no longer act. So there'll be the most common for kids under a certain age. Second of all, if you've got a child with permanent disability, so you may have to have something for their lifetime. And again, it's important in that case, even if you're appointing your brother now, you may want to put a backup. And even if your nephew is 16 at this point, maybe he's a brilliant kid, and by the time he's 30, he could take over from his father. Mm-hmm. And the third one, which is quite common, is second marriages. So you could have people in their 70s who get remarried, and they've got an agreement where the house can be kept for the second wife for her lifetime, but upon her sale, the house is disposed of. So it means that the estate can last for many more years. So again, when you're appointing the executor and trustee, you need to know that there's somebody who'll be around. And if you don't think they're going to be around for the duration, make sure you've got a backup in there. And it may be somebody who at this point isn't quite ready to be in charge, but you're confident by the time the person's 30, they've reached that stage in life that they can take over. When
is it beneficial to have an outside entity, like either our trustee companies? Is that what they are?
Well, first of all, there's nobody. If let's say you live here and all your family live in England, and there's nobody else who can be in charge of it. Or sometimes what happens, you've got children with serious mental health issues where it's very difficult for other family members to deal with that person. You can name a professional company that, or else sometimes it's incredibly complex. So there are reasons. The reality is a lot of trust companies aren't really interested in acting unless the estate is worth a few $1 million as well too.
Because they can build that 5% back.
Well, it's you have to administer. Sometimes there's more work administering a $250,000 estate than there is a $6 million estate. So, and if you want to use a trust company, they'll have you sign a fee agreement as well. So they're available. And
I've also heard of somebody asking their attorney to do this kind of work. Is this something you guys shy away from?
Yeah, lawyers used to want to do that, but the problem is that I've had to do it, and I don't really, you as executors, a lot of work, and sometimes when you're having to go through a stranger's house, and you have to go through the sock drawers and things like that, because sometimes that's where things are hidden, and it's not something I relish. Lawyers used to do a lot more than they do now, but and also the issue is, what if I retire? John's younger than I am. We have a 31-year-old lawyer who could take over too if need be, but it's something that I don't seek out.
Now, we have about a minute or so left here. Final thoughts, advice. Somebody, as you mentioned, maybe 60% of the listening audience has a will that's current. What's your final thoughts on this?
Well, if you're in the 40%, and you don't have a will that's current, do what John suggested at the beginning, which is get a legal checkup. Have somebody look at it. Maybe your will is perfectly suitable. It's likely to be valid if it was valid back then. It's probably still valid now, but it may no longer reflect your current circumstances. It's probably a good idea to have somebody look at it. Maybe there are suggestions that could be to be made for improvement. So that would be my number one piece of advice on this, is just think about these issues while you still can.
I just add this: you should know where your will is.
Right.
And second of all, you should review it. And I'd say usually a good time of year is around the same time you file tax returns at the end of April. Maybe it's a good time to review your will too, because every now and then we all have those years from hell that.
Yeah. We've all lived them, and and obviously a show like this, I'm sure, reminds a lot of people. And it's been great having you both on the show. John Lakes and John White, partners at Lakes White LLP in North Vancouver. They are a law firm experienced in estate planning and estate litigation, and we have been talking about the basic rules that constitutes a will, and we'll have them back again here right on the Law Show next time on CIAL 650.